President Trump was told to turn the National Guard control over to California Governor Gavin Newsom. They were initially called in to assist in immigration enforcement in controlling unrest. That order, which was supposed to take effect at noon, said the deployment of the Guard was illegal and both violated the 10th Amendment and exceeded Trump's statutory authority. I can tell you, as of this moment, an appeals court has since paused that ruling. Joining us now to discuss this is Mr. John O'Connor. He is the author of Postgate, How the Washington Post Betrayed Deep Throat, Covered Up Watergate, and Began Today's Partisan Advocacy Journalism. Sir, thank you so much for joining us on the Live Zone. So as you heard me make mention, an appeals court, in essence, has now paused the ruling. I'm hoping for those of us that are still trying to wrap our heads around with regard to what's going on, you can elaborate.
Yes, the president has power under the Militia Act of 1903 to call in the California or the state National Guard, federalize them in other words, only in certain situations. But two of those situations is, one, a rebellion against the authority of the United States, or the inability or a danger of rebellion, or number two, an interference with the ability to execute the laws of the United States. So President Trump has argued that under either one of those two or both, he can federalize the National Guard. That is to say, these protests amount to a rebellion against the authority of the United States to execute its immigration laws, or alternatively expressed, we cannot execute the laws as we wish because of this, and so therefore we need the National Guard. Now, the judge has written what I consider a brilliant kind of textbook opinion. It's just that it takes all the arguments, in my view, to an extreme, because the statute allows this decision to be made in the sole and exclusive discretion of the president. So the judge says, no, wait a second, yes, it's in your discretion, but wait a second, before we even get there, I'm the guy that determines whether there's a rebellion. I determine whether you're unable to execute the laws. It's not your decision, it's my decision. And I think a fair reading of the law would say it's the president's decision, and the court should jump in only if it's just absolutely crystal clear that he doesn't have discretion, he's just abused his discretion. So it's very much of a law school opinion that one can debate, and I think Judge Breyer's a brilliant guy. He's the brother of the Supreme Court Justice, so I have nothing but praise for his judicial abilities. This is just simply what I would say an interpretation of the law, because I don't think the judge likes what Trump did and doesn't think it's necessary, and it's really sort of his view that this was unnecessary, so he's using this law to countermand him. I think it's a serious issue because the one thing the president should be able to do is control, as the commander-in-chief, is to control our armed forces, whether it's a state militia, the National Guard, that's I believe is paid for from federal funds, but and enforce the laws of the United States. If you go back to the Whiskey Rebellion and the Shays Rebellion at the time of the Constitution, those were rebellions against the tax collectors in Western New York and in Western Pennsylvania, because they made their own booze and there was a tax on booze. And so that's all it was. It wasn't a rebellion against anything else. And it's like this. This is a rebellion against enforcement of the immigration laws, much like Shays Rebellion and Whiskey Rebellion were rebellions against taxing authority on liquor excise taxes. So it's a very important decision. I'm happy that the appeals court has stayed it, because I think it needs more than one judge looking at this. I think it needs a number of judges that are going to look at this and have a healthy democratic debate as to whether this falls within the executive branch's authority. This is a very much of an issue of separation of powers. To what extent can the judiciary invade the president's lawful discretion And it's not clear. You're in a gray area, and it's not
Sure.
clear. I will say that for Judge Breyer.
Mr. O'Connor, I got about a minute left, and you were so kind to join us. Obviously, yet again, you were the author of Postgate, How the Washington Post Betrayed Deep Throat, covered up Watergate, and began today's partisan advocacy journalism. Folks that want to get their hands on your book, how would one go about to do so? And very briefly, tell us what we should expect should we have the opportunity to read it.
If your audience goes to postgatebook.com, you'll see several of my books, including Postgate, and it gets right to the nub of how the media has now gotten over its skis into being a political power, a political force that's partisan, all as a result of Watergate and what it did in Watergate and getting rid of a duly elected president. It's still going on today, and we know that, we see that, and thank God for media like yours, which are now competing with some of the legacy, national legacy media.
Very good, sir. Yet again, we have been speaking with Mr. John O'Connor, kind enough to join us on the Live Zone. Make it a great weekend, sir.
Thank you.